Hi everyone, and welcome to week 6 of Reproduction and the Law, our last week, if you can believe it. We've spent the last couple of weeks talking about the legal parameters of reproductive rights. We spent the first few weeks talking about the underpinnings of the privacy right and the abortion decisions, moved on to the specific abortion rights of populations such as minors and incarcerated women, and then moved on to looking at how technology influences this area of law, and finally figured out how to balance reproductive rights with other rights, such as speech and religion. This week we're going to spend some time talking about reproduction and the workplace, and specifically the guarantees in federal law that prohibit discrimination based on reproductive capacity in the workplace. Things like the Pregnancy Discrimination Act and the Family Medical Leave Act. This is a topic that's near and dear to my heart as a working mom, so it's really interesting to sort of explore the laws that offer protection and then look at the new ones that are coming down the pike. Title VII of the 1964 Civil Rights Act prohibits discrimination in employment on the basis of things like race, color, sex, and national origin. We're specifically interested in the prohibition against discrimination based on sex. Now, Title VII not only protects you from being not hired or fired because of your sex, but also protects you in your terms and conditions of employment. That's things like how much you're paid, what your benefits are, what your leave is. Those are all considered terms and conditions of employment. Now, the question had been for many years, the 1964 Civil Rights Act was obviously passed in 1964, and the question had been, does sex, the prohibition against sex discrimination, include pregnancy discrimination? And for many years, the courts were saying no, that pregnancy discrimination was not a form of sex discrimination. The courts were saying things like, pregnancy is voluntarily undertaken. Therefore, it does not rise to the same level of things like sex discrimination, race discrimination, attributes that you cannot change. Pregnancy, the courts were saying, you can choose. Courts were also saying that if you discriminate against someone based on the fact that she is pregnant, that's not sex discrimination. Whenever you're talking discrimination, the courts look at the two classes of people to be compared. For example, a white person and a black person, a man and a woman. The court said here that pregnancy discrimination was discrimination between pregnant people and non-pregnant people, and therefore was not sex discrimination. Of course, this ignores the fact that only women can become pregnant, right? So after a series of these decisions, Congress acted, and in 1968 specifically amended Title VII of the 1964 Civil Rights Act to make clear that sex discrimination includes pregnancy discrimination. I've posted Title VII for you to read. You'll find that amendment in Section K. And Section K makes clear that sex discrimination includes pregnancy discrimination. The section specifically says the terms because of sex or on the basis of sex include but are not limited to because of or on the basis of pregnancy, childbirth, or related medical conditions, and women affected by pregnancy, childbirth, and related medical conditions. That term, related medical conditions, which we see twice within the Act, has caused a lot of controversy within the courts, specifically trying to figure out what that means. And one of the latest battles the courts are looking at is whether a related medical condition is the need to have contraception to prevent pregnancy. And we see this arising in this way. When employers select health insurance plans, they select plans with certain benefits. And if an employer selects a health insurance plan that does not include coverage for contraception, is that sex discrimination and pregnancy discrimination? Because as of now, the only prescription contraceptive on the market is the birth control pill. Meaning that it's only available for women, right? There's no prescription contraceptive for men. So the question then becomes, is refusing to cover that employment discrimination? The courts have been somewhat divided on this. The EEOC has said, yes, that is employment discrimination, but just recently a court in the the 8th Circuit Court of Appeals said, no, that's not employment discrimination. And I've posted that decision, the Union Pacific decision, for you to read. So I want you to read the Pregnancy Discrimination Act, read Union Pacific, and try to figure out, did the court get it right or did the court get it wrong? Does coverage for contraception fall within the Pregnancy Discrimination Act? Is contraception related to pregnancy? Or is it, as the court said, the direct opposite of pregnancy? You're trying to prevent pregnancy, so there's no way non-coverage could be pregnancy discrimination. Another area that I wanted to spend some time talking about, again from the working mom angle, is parental leave. Currently, an employer does not have to provide you with paid parental leave. The protections we have in federal law are the Family Medical Leave Act, which provides for 12 weeks of unpaid parental leave, meaning for a man or a woman who is a parent, and including giving birth, or your partner giving birth, or adopting a child. So it's unpaid 12 weeks of leave. And the Family Medical Leave Act also provides that when you go back to work, you have to get substantially your same job back. Meaning if you take the 12 weeks unpaid leave, they can't fire you for doing so, right? So the question then becomes is this enough, right? A lot of employers will go a little bit above and beyond that, providing some paid leave. For example, American University provides somewhere between 6 and 8 weeks of paid leave after childbirth. Federal workers have not had such protection in the past, and just recently, just this month actually, the House of Representatives passed a bill, H.R. 626, that deals with paid parental leave for federal workers. And what it would do is, of those 12 weeks unpaid leave that workers are entitled to, for federal workers it would make 4 of those weeks paid. So a couple of questions arise. Again, 4 weeks, is that enough? Right, you got a 4-week-old baby. Is that enough time? 2, the Family Medical Leave Act, the 12 weeks of unpaid leave. Is this really a benefit for people? How many people do you know who can afford to take 12 weeks of unpaid leave? I certainly can't at this point. And there are a lot of people where 12 weeks of unpaid leave is just not a realistic possibility. Third question, H.R. 626. In theory, 4 weeks, great. Let's give people the ability to spend some time with their infant son or daughter and to do that bonding, right? But is this a responsible move on the part of government? We are in a time when we're in a recession. We're in an economic crisis. Should the government now be taking on the financial responsibility of providing for leave? Okay? And then think about how the U.S. policy towards parental leave differs from other countries. Spend some time Googling, figure out what other countries do, and you'll see that in many regards the U.S. is sort of behind the curve in terms of parental leave. So think through these issues. Think through Title VII, sex discrimination, the Pregnancy Discrimination Act, Family Medical Leave Act, and then recent efforts to make paid leave available to federal workers. I'll see you online.